Hi, I'm John Cannon, founder and owner of Cannon Associates. And in this video, I'd like to talk to you about military divorce and the nuances of that process. We're dedicated to serving service members and their loved ones in these cases based on our personal experience. I'm a currently serving judge advocate in the Oklahoma National Guard and a field grade officer. And I'm dedicated to serving the service members I have the privilege of working with and serving not only in my law firm, but in military service. Many family law attorneys will take on military cases, but may not have the requisite experience or have worked with sufficient number of service members to know the ins and outs to ensure that they protect your interests and protect your rights. One important consideration in military divorce is what is and what is not a marital asset. Military retirement, which is the most valuable asset for 90+% of service members or their spouses going through a military divorce, is a divisible marital asset. There are many other things that could or could not be these types of assets, and in this video, we'll walk you through those issues. I will jump to the most important issue for many of you first, the division of military retirement. It is a divisible marital asset. However, and most importantly, your spouse is only entitled to a portion of that retirement for time that overlap between your marriage and their military service. Some military retirement accounts can be worth upwards of $500,000 or even $1 million if the service member has served long enough and achieved a high enough rank. The defined benefit plan and historic plan includes your base pay, high 3 years of service as far as income, the length of your service, and a 2.5% multiplier to calculate the amount of retirement that you're entitled to. Now that's a pretty complicated math. And it's important that the attorney you retain to help you ensure your rights are protected in this important asset knows how to do these calculations and has done them multiple times. There's a newer system that's the defined benefit plan for newer service members, and it is a similar calculation with only a 2% multiplier. The difference in correctly applying which version of military retirement can result in you gaining or losing hundreds of thousands of dollars. It is vital that you retain an expert that knows this area of family law. One of the other most important benefits to consider is military medical benefits, Tricare. Hundreds of thousands of service members across the country benefit from the use of Tricare every day, and it is not a divisible marital asset. You either are or are not entitled to it statutorily. The 20-20-20 rule and the 20-20-15 rule dictate your eligibility. If you are married to a service member with 20 years of service, 20 years of marriage, and 20 years that overlap or more, you are entitled to Tricare for your life unless you remarry. Alternatively, if you're married to someone who had 20 years of military service, 20 years of marriage, but only 15 years or more of overlap, you're entitled to only 1 year of this incredibly important benefit. If less, no benefit at all. It's important to know when you qualify for this asset and ensure that it's protected during your military divorce. There are many other important military benefits to consider. First and foremost is the basic allowance for housing. This is something that's provided to a military member for their housing expenses dependent on the geography of where they live, specifically the zip code. This is not a divisible marital asset. If you are separated from your spouse, however not divorced, you are still considered that person's spouse under military regulations, and you are entitled to this benefit. Another important consideration is VA disability compensation. This is not a military divisible asset. However, a service member can elect to waive a portion of their military retirement income for this benefit. If you have a straight line divorce decree concerning the division of military retirement, that service member's spouse may divest you of part of that benefit years later. That's why it's so important to retain an experienced military divorce attorney and ensure that there is a catch-all that if someone were to divest an interest that you have, there must be comparable compensation to make up for that divestment that they take. Another important consideration is the Thrift Savings Plan, or TSP. This is a divisible marital asset. It is the military's equivalent of a 401k. If the service member pays into it during the life of their military service, then they will receive this benefit down the road. You as a service member need to seek to protect this, and if you are the service member spouse, you have an interest in this benefit. Post 9/11 GI Bill is a benefit that the Congress has given to service members that have honorably served in our military. It can pay for tuition for a 4-year college books, housing, and sometimes these benefits are upwards of $160,000 or $200,000. This is not a military divisible asset. However, a service member can grant this benefit to their spouse or their children, including a former spouse. If you are the non-service member seeking to higher your education or attend college or want a specific child to receive that benefit, it is something that you can codify in your divorce decree and potentially seek to enforce against that service member. One of the other very important benefits to consider is access to military installations. With the military ID or CAT card, you can access any installation in the United States. One of the benefits of this is access to tax-free shopping, grocery store, and other services that are provided on military installations. Typically, service member children under the age of 10 are not issued ID cards. However, if a service member's child does not primarily reside with the service member, then you can force that they be issued a card under relevant AFIs. And that would, in fact, grant you access as the non-service member on the base to serve your child with the benefits available to them on the installation. I'm John Cannon, owner and founder of Cannon Associates, your fierce advocate. I'm a judge advocate in the Army National Guard and a field grade officer. We are dedicated to fighting for service members and their spouses if need be in a military divorce action. It's important that you know the rights that you have and you seek to protect them. In today's video, we've touched the surface only on a number of these important issues. If you have questions or think that you may be facing a military divorce in Oklahoma, we welcome you to reach out to us for a free confidential case evaluation. We'd be happy to walk you through these issues, whether you decide to work with us or not. For more information, please visit our website for a number of articles and content on these issues, or feel free to call the office.